speakers, esteemed participants, good afternoon from Jakarta and also good morning in Europe. On behalf of the Ministry of Foreign Affairs of the Republic of Indonesia and also the Indonesian Society of International Law Lecturers, it is my great pleasure to welcome you to today's webinar entitled Contemporary Legal Issues in Space Laws, Recent Developments under the United Nations Committee on the Peaceful Uses of Outer Space. Allow me also to extend a special welcome to His Excellency Damus Agusman, Ambassador of the Republic of Indonesia to the Republic of Austria, His Excellency Riku Suhendar, Director General for Legal Affairs and International Treaties, Professor Ari Afriansyah, the Chair of the Indonesian Society of International Law Lecturers, and also our moderator for this webinar, Mr. Alif Nur Fakhri Muhammad, and our distinguished speaker, Ms. Rosanna Hoffman, the lead of the Space Law and Policy Global Space Law Project at the United Nations Office for Outer Space Affairs. My name is Parardia Narasvari, and I am honored to serve as the Master of Ceremonies for today's webinar. The webinar provides an important opportunity to examine recent legal developments concerning activities in outer space, particularly within the framework of the United Nations Committee on the Peaceful Uses of Outer Space. Before we begin, we kindly invite all participants to keep their microphones muted throughout the presentation. Any questions may be submitted through the chat box and will be addressed during the discussion session. Firstly, our first opening remarks will be delivered by His Excellency Damus Agusman, our Ambassador of the Republic of Indonesia to the Republic of Austria. Your Excellency, may we kindly invite you to deliver your opening remarks.
Thank you very much, Your Excellency, DG Ricky Suhendar, and Professor Ari Afriansyah as the Chair of the Indonesian Society of International Lecturers, and of course, Madam Rosanna Daim Hoffman, lead of the Space Law and Policy with the United Nations Office for Outer Space Affairs, UNOSA. And distinguished participants, ladies and gentlemen, of course, it is my great pleasure to join you virtually from Vienna for this webinar. The permanent mission of Indonesia in Vienna is delighted to be part of this timely initiative in collaboration with Indonesia Ministry of Foreign Affairs and also with collaboration of Indonesian Society of International Law Lecturer. I myself is also part of the Indonesian Society of International Law Lecturers, so I'm very pleased to be here with the webinar. Of course, I wish to thank Madam Rosanna Daim Hoffman from UNOSA for taking the time to share her expertise with our colleagues and participants in Indonesia.
Yeah.
This webinar, of course, reflects Indonesian commitment to strengthen our knowledge and capacity while remaining actively engaged in international discussions on space law policy and governance. In 2020, the international community will mark the 60th anniversary of the Outer Space Treaty, which remain the cornerstones of international space law. It is therefore it is timely opportunity to reflect on what has been achieved over the past 6 decades and what remains to be done. So a number of questions arise. Has the Outer Space Treaty been fully and effectively implemented by all state parties? And the question also arises on, are there emerging issues in space activities that remain unaddressed by any of the 5 United Nations treaties on outer space? And is there room for soft law to help address this gap in space governance? So these are among the questions that today's webinar is hopefully to explore, and we consider and to consider, of course, how international space law can respond to the challenges ahead. Since becoming a member of COPWAS in 1973, Indonesia has actively promoted the peaceful use of outer space with particular attentions to the interests of the perspective of developing an equatorial country. So as one of the earliest country in Southeast Asia to develop a national space program, Indonesia has consistently supported international cooperation in space science, satellite technology, and capacity building. So through our participation in Vienna and in the subcommittee of the UN COPWAS, Indonesia has contributed to discussions on space law, the sustainability of outer space activity, disaster management, remote sensing, and equitable access to the benefit of space science and technology. Indonesia has long also promoted the use of space application for disaster risk reductions while consistently advocating the rational, efficient, and equitable use of the geostationary orbit as a limited natural resource. This further reflects our commitment to ensuring that the benefit of outer space are shared by all nations. So on the development at national level, at the national level in Indonesia, I believe Mr. DG will further elaborate on this. So I like as a last part to focus on what the current issue in Vienna. So recent deliberation in COPWAS and in its subcommittee demonstrate the breadth of legal and technical issue pertaining to space. So discussions continue to take place regarding definition and delimitation of outer space, the geostationary orbit, space debris mitigation, space traffic management, and small satellite activities, and the exploration of use of space resources. We are also seeing an increased attempt to discuss the establishment of non-use of force at space within COPWAS, which coincide with the discussion also taking place in Geneva and New York under the preview of disarmaments. So this is also new challenges ahead. And additionally, an initiative on space for development has also emerged to address the gaps in capacity and technological expertise between developed and emerging spacefaring nations. And archipelagic and island states also held exchange of view on potential benefit of space technology for their specific needs and interests. So as deliberation progress, we may see more contemporary issues emerge that require renewed legal and policy attention to ensure the continued peaceful, safe, and sustainable use of outer space. So, ladies and gentlemen, I'm confident that today's webinar will not only shed light on recent development in COPWAS, particularly its legal subcommittee, but also highlight key legal issues that will require further considerations in the year ahead. Through our permanent mission in Vienna, Indonesia will continue to work closely with UNOSA to advance international cooperation and strengthen national capacity in space law and policy, including through today's webinar. It is my hope that the views exchanged today will provide useful insight into how Indonesia can further strengthen its role and contribute constructively to deliberation in COPWAS and its subcommittees. I wish you a productive discussions and a successful webinar. Thank you very much.
Thank you, Your Excellency, for those insightful opening remarks. We will now hear opening remarks from His Excellency Riki Suhendar, Director General for Legal Affairs and International Treaties of the Ministry of Foreign Affairs of Republic of Indonesia. Your Excellency, the floor is yours.
Thank you, Ms. Paradia, for kind introduction. Ambassador Dr. Damos Agusman, Ambassador of Indonesia in Austria and to the United Nations. Ambassador Damos is my mentor, so I think I'm I'm not eligible to talk here in front of him because he's my professor. But due to my task, then I have to deliver my keynote. And my dear friend, Professor Arya Friansa, Chair of Indonesian Society of International Law Lecturers, Ms. Rosanna Hoffman, lead of the Space Law and Policy Global Space Law Project at the United Nations office in Vienna, distinguished participants, ladies and gentlemen. It is an honor for me to participate in this important webinar on contemporary legal issues in space law, recent developments under the UN COPOS Legal Subcommittee. So on behalf of Ministry of Foreign Affairs, I wish to express my sincere appreciation to the Indonesian Society of International Law Lecturers, or ISIL, for its valuable partnership in organizing this important capacity building initiative. And also to my mentor Ambassador Damos for sharing recent development on this issue in multilateral forum. I would like also take this opportunity to extend my gratitude to Ms. Rosanna Hoffman for accepting our invitation to share your expertise and of course valuable insight with us. I believe that your presence reflects UNO's continued commitment to promoting wider understanding on international space law and fostering international cooperation in peaceful uses of outer space. Distinguished participant, outer space activities are entering an era of unprecedented transformation, rapid technological innovation, the growing participation of private sectors, and the expanding scope of space exploration and commercialization are fundamentally reshaping the global space environment. These developments have created new opportunities for scientific investment and sustainable development, while at the same time giving the rise to increasingly complex legal, regulatory, and governance challenges. As a result, the international community is confronted with a range of emerging legal issues that require careful consideration. Questions concerning the adequacy of existing legal frameworks, the sustainability of outer space activities, and the balance between technological progress and responsible governance have become central to international discussions on the peaceful uses of outer space. Like Ambassador Damos mentioned before, that the discussion and developments in international space law within the legal subcommittee of the UN COPOS have also influenced the evolution of Indonesia's national space policy. Indonesia ratified the Outer Space Treaty in 2002 and subsequently enacted law number 21/2013 on outer space. Thus, building upon this legal framework, the government also enacted Government Regulation number 4/2017 on the Master Plan for Space Activities 2016 until 2040, which serve as a strategic framework guiding national stakeholders in the planning and implementation of space activities. Distinguished participants, ladies and gentlemen, again, this backdrop, strengthening Indonesia's national capacity in international space law has become increasingly important. As developments in outer space continue to accelerate, it is essential that government officials, academics, and legal practitioners and other relevant stakeholders possess a sound understanding of the evolving international legal framework. Such understanding will enable Indonesia to participate more actively in international negotiation, formulate well-informed national policies, and safeguarding our long-term national interests in this rapidly developing domain. In particular, I wish to emphasize the indispensable role of the academia, universities, and research institutions serve not only as a center of knowledge, but also as incubators for future legal scholars, policymakers, diplomats, and practitioners. So I believe today's discussion will enrich academic research and inspire future scholarly publication, allowing these important developments in international space law to reach a much broader audience. So finally, I hope this event will serve not only a forum for learning, but also as a platform for exchanging ideas, strengthening professional networks, and fostering closer collaboration among government institutions and international partners for progressive development of international space law. So I stop my intervention. I thank you very much.
Thank you very much, Your Excellencies, for the valuable remarks. We would also like to welcome Professor Ari Afriansyah, Chair of the Indonesian Society of International Law Lecturers. We will now hear the remarks from Prof. Ari.
Thank you very much, Ms. Faradia. Excellencies, Mr. Ambassador, Dr. Damos Agusman, my also teacher and my mentor, DG Ambassador Ricky Sohendar, of course, the main resource person for our webinar today, Madam Rosanna Dem Hoffman from the UN Office of Outer Space Affairs. Assalamualaikum warahmatullahi wabarakatuh. Thank you very much for this afternoon event in Jakarta or Indonesia, or in the morning in Europe. On behalf of the association, the Indonesian Society of International Law, that is consists of lecturers who teaches and research in international law in general. We are very grateful for this cooperation with the Ministry of Foreign Affairs, especially the Director General of Legal Affairs and Treaties. This event very much facilitated institutionally, and we are so much will be enlightened, because for our information that international law scholars in Indonesia is a small community, but then those who are focusing on space laws even more limited. So this is like a hidden gem community in Indonesia, let alone of other relevant areas of teaching and research. So this is one of the important for Indonesia, because in the future, as Mr. Ambassador Damos and also Ambassador Ricky have mentioned, that Indonesia is embracing a number of development. That's why scholars like our association is very much looking forward for any um, information, any updates that might enable us, yeah, to explore more ideas, more be explored towards our own journey of teaching and research. I guess I will not have a long speech because the things that Madam Rosana will deliver is the one that we are waiting for. Again, on behalf of the institution, the ISIL, I'm thanking very much for the Ministry of Foreign Affairs of Republic of Indonesia for this cooperation, and I hope this would not be the last, and certainly will be follow up with further cooperation. Thank you very much. Wassalamualaikum warahmatullahi wabarakatuh.
Thank you. We greatly appreciate ISIL's continuing contribution to the advancement of international legal scholarship and dialogue in Indonesia. And for now, Excellencies, distinguished speakers, and participants, we will now proceed to the main session of today's webinar. It is now my pleasure to introduce the moderator for today's session, Mr. Alif Nur Fakhri Muhammad. Mr. Alif is a lecturer in the International Law Department of the Faculty of Law in the University of Indonesia. He also serves as assistant to the faculty leaders for academic affairs and as researcher at the International Law Studies Center, Lembaga Pengkajian Hukum Internasional of the Faculty of Law, Universitas Indonesia. In addition, he is member of the editorial board of the Indonesian Journal of International Law. Mr. Alif obtained his Bachelor of Laws degree from Universitas Indonesia and completed the Advanced Master of Laws in Air and Space Law at Leiden University in the Netherlands. His academic and research interests focus particularly on the international air and space law. His publications have addressed, among other subjects, the admissibility of Earth observation data in legal proceedings, military activities in the outer space, geostationary orbit, satellite orbital slots, and the Artemis Accords. He has also contributed to research concerning the development of Indonesia's legal framework for the related to the space sector. With his academic background and research experience in the international air and space law, we are very pleased to have Mr. Alif to guide today's discussion. And also, I am pleased to hand over the session to our moderator, Mr. Alif. Please, Mr. Alif.
Thank you, Ms. Epsi. Thank you all for coming to our webinar this afternoon. Now, this webinar is part of ISIL Talks, which is a periodical webinar organized by the Indonesian Society of International Law Lecturers, which covers broad issues of international law. The 21st session of this webinar will cover the contemporary legal development in space law, specifically recent development in the UN Committee on Peaceful Uses of Outer Space. Now, without further ado, I would like to invite our speaker today, Madam Rosana Daim Hoffman. She is the head of Space Law Policy and Sustainability at the United Nations Office for Outer Space Affairs, where she leads the Global Space Law Project. In this role, she advises UN member states on the development and implementation of national space legislation, space policy, and regulatory frameworks, supporting countries in meeting their international obligation while fostering responsible, safe, and sustainable space activities. Her work includes technical advisory missions, legislative drafting support, and legal and institutional capacity building for emerging and established space actor. Now, I would like to underline the legal and institutional capacity building part because since the seminar is part of the ISIL program, we have discussed earlier on when preparing the webinar, basically that space law isn't something that is widely known for law students in Indonesia. And as law lecturers, it is part of our mission to deliver all subject of international law including specifically the space law. Now, without further ado, I would like to invite Madam Rosana Devhoffman to deliver her material.
Thank you so much. Thank you for the very kind introduction, and excellencies, thank you for your really thoughtful, I would say, thoughtful and awareness-raising opening words. Let me first share my screen so that you're able to see the slides that I've prepared, and if you could just please confirm that you can see them fully.
Yes, it's
Yes.
yeah.
Thank you so much, Alif. And terima kasih. Thank you so much for having me. I've been to your lovely country, Indonesia, several times. I fell in love with Surabaya and Jakarta and Jakarta anyways. So believe me when I say I wish I was there with you in person, but online is fine as well, of course. And I'm excited to hear that this topic is of interest to you, to the audience that you do this webinar for. And of course, I'm very grateful to the permanent mission of Indonesia here in Vienna for putting this together as well from their end. Of course, we are always grateful to see permanent missions involved in pushing these types of things forward nationally. It's really where the interplay between what we do here in Vienna and, of course, all the work that you do in capital shows its fruits. So I was asked to cover, as you already very correctly said, the contemporary legal issues in space law. Now, when I don't do capacity building work within the Office for States, I am in fact a lecturer at many universities, and I could talk about this topic for many hours, but I will keep it short because I was also specifically asked to focus on the recent developments at COPUS, so the Committee on the Peaceful Uses of Outer Space. So that is what I will focus on. I have added some slides at the end that look more into the legal issues that are, I would say, contemporary in regards to the UN space treaties and the non-legally binding instruments that are happening outside of COPUS as well. And if we don't get to it, of course, I will share the slides with the organizers right after my intervention. But I will focus strongly on what is currently happening. So covering first, of course, for those of you who might not have heard of this very small, but I would say very effectful office of the United Nations, the Office for Outer Space Affairs, then looking into COPUS, the Committee on the Peaceful Uses of Outer Space, the current working mechanisms, that will be the focus. So what are the different areas of work, especially from a legal perspective, that should be of interest to you, to Indonesia, especially as a lot of the working mechanisms now are moving towards the end of their mandate, meaning that the outcome of that will be quite important, I would say, for you and for your space programs and space activities, because the outcome will be guidelines, recommendations, principles that will be adopted as hopefully resolutions. So it is important that you're aware of the issues ongoing and being discussed at COPUS. We will also delve into the existing international framework, but only use it to look into the contemporary issues, then somewhat UNOSA's other mandates, and very briefly the Space Law Project. So UNOSA, the United Nations Office for Outer Space Affairs, you see here on the picture, we're a small team, although I have to say this is the team based in Vienna. We also have offices in Beijing and in Bonn in Germany. But the offices in Beijing and in Bonn deal mostly with disaster management. I would say the legal and policy team is in Vienna, and I'm happy to be heading that team. And we are first and foremost a convener. Convener meaning the secretariat to the Committee on the Peaceful Uses of Outer Space. We facilitate global cooperation among UN member states, but we're also a gateway to accessing space. We've helped states launch their very first satellite, access space data, access information on space law and policy. And what's a bit different between, I would say, us and a lot of other UN entities dealing also with space is that we're the sole UN entity dealing exclusively with space. There is no other issue at hand that we deal with. And of course, we're also a capacity builder, an action-oriented office, and the webinar today is one example of that. Historically, when we say we were established in 1957, officially we were established by a resolution in 58, but 57 is an important year because that is the year that Sputnik, the very first satellite, was launched into space. And already within that year, in 57, a handful of states came together in New York and said, we need to ensure, now that we know that space activities are becoming a reality, we just saw it happen, we need to have some type of forum, some type of mechanism needs to be in place that we are able to discuss the peaceful uses of outer space. We need to be able to discuss information sharing. We need to be able to discuss the legal regulatory foundation for space activities. It should not become a Wild West. Whenever I read outer space is the Wild West, I get hives because it's not, as you very well know. But already in 57, that was at the core of the discussions. So in 58, it was then officially established and it was moved to Vienna in 92. And my director always likes to point out here that she doubts member states would have agreed to moving UNOOSA to Vienna in 92 had they known what space would be today, our reliance on space. Personally, I'm quite thankful that we were moved to Vienna. I think it's more beautiful than New York. But in any case, the mandate, of course, is clear for us as an office. It's about international cooperation, capacity building around technical aspects, legal, policy, and scientific, all in regards to space. But what is interesting to see is that that mandate has grown significantly. At the beginning, the office was purely there to serve as a secretariat to COPUS. And since then, it has grown from, as I said, work in regards to disaster management, space law and policy, access to space, space for women, space for youth, and so much more. And of course, we also, and we'll look at that a bit more later, but we are also maintaining some of the core functions of the United Nations space treaties. That includes the UN Register of all space objects launched. That also, however, includes the Register of all objects re-entered and landed on foreign territory. And I'll show you some examples. And it also includes information sharing under Article 11. That's one of the contemporary issues, by the way, being discussed in the legal subcommittee. So that has also expanded and become more and more relevant as activities grow. Now, I mentioned UNOOSA, and it's always important just to distinguish the two. What is the UN Office for Outer Space Affairs and what is COPUS, right? UNOOSA is a UN office. It's UN staff working, and we service the committee. The committee, or COPUS, is of course a committee by member states. It's member states with a voice. It's member states, as you see here on the picture, that meet 3 times a year. And we see that the interest in joining COPUS as a member state is growing significantly, from 18 member states in 1959, when the committee was established as a permanent committee, to 110 in 2025. And already this year, we will most likely see more member states because membership is agreed at the 4th committee in New York. So it will be interesting to see how that will grow. We have several applications for membership. COPUS meets 3 times a year. As I said, we have 2 subcommittees. Your permanent mission knows it very well. They attend those meetings. but so do, of course, delegates from Capital, most likely Bryn. But we have two subcommittees, the Scientific and Technical Subcommittee that meets in February, the Legal Subcommittee that meets in April, and then we have the main committee that just met, in fact, in June. Indonesia has been a member state of COPUOS for many years now, since 1974, in fact, which is a testament to how involved you are, and of course also the fact that you have had a space program for quite some time. But it is interesting to see, of course, with the new and emerging topics being discussed. And of course, it's always difficult, I would say, to attend all of these different meetings that are happening in parallel. And we'll look at those topics specifically and which ones might be of most interest to you. Importantly is how decisions are made. And apologies if this is a bit of repetition for those of you attending COPUOS meetings, but this is an important point, especially when we look at non-legally binding instruments or soft law, as was mentioned by His Excellency at the opening. Consensus is an important way of taking decisions. And in fact, historically, it is very interesting that COPUOS was the first committee of its kind under the General Assembly that decided that all of its decisions would be taken by consensus. There are several more now, but back in the 1950s, it was the first that decided that there would not be any vote, right? You don't need a majority. What you need is everyone in the room to agree, or at least, this is also a definition of consensus, to not disagree, right? And why is this important? And we'll look at it from a timeline perspective as well, but you know that we have 5 United Nations treaties. These are legally binding if you've ratified them. Some principles even reaching the status of customary international law. But the treaty-making era ended in 1980, and then came the era of non-legally binding instruments, principles, resolutions, guidelines. But even though these are non-legally binding, meaning they're not automatically binding on you as a state once they're adopted and agreed, they have a strong legal effect because of the way that they were agreed, namely by consensus. Everyone in the room has a buy-in, has a sense of ownership over what was agreed and a sense of wanting to adhere to it because of the way that it was agreed, namely by consensus. So I hope what I said makes sense. Believe me, it has a strong legal effect. COPUOS reports to something called the Fourth Committee, which is part of the General Assembly, and every year UNGA, a United Nations General Assembly resolution, is adopted, which includes the COPUOS report. Okay, so I said there would be a timeline, and here it is. Very briefly, just to mention again, COPUOS with its resolutions in the 50s and 60s, the basis for everything coming then in the 60s, 70s, and 80s, 60s to 80s, the time of the treaties, the binding international treaties of international law, with the Outer Space Treaty, Rescue and Return Agreement, Liability Convention, Registration Convention, and then finally the Moon Agreement. Then we have a set of principles. We'll look at it, the development of soft law or non-legally binding instruments, the latest being the long-term sustainability guidelines from 2019. However, hopefully, if we can find consensus in the committee very soon, additional non-legally binding instruments, latest by 2027, and we'll look at it, potentially guidelines in regards to space resource activities, potentially recommendations on space traffic coordination, recommendations on the establishment of a lunar coordination mechanism, and so forth. So a lot is coming up, and therefore my call on you, please participate in all of these discussions, because it will make a difference. Important also here is the Pact for the Future. The Pact for the Future from 2024, where Action 56 is specifically relating to space. And Pact for the Future is important because it is a call to action by heads of state that met in New York at the General Assembly. And they called specifically on COPUOS to focus on three things, and three things from a legal perspective: space debris, space traffic, and space resources. So when we talk about contemporary issues, we need to go back to the Pact for the Future from 24 and see, are we actually doing what we are being called upon to do? Are we addressing these three issues and more, I would say. So what do we have? I said we have the main committee with its two subcommittees, and now we really get to the nitty and gritty, the mechanisms that are in place to discuss the contemporary issues of space law. And you would think I would only focus on the legal subcommittee, but in fact, we do also need to focus on what is happening in the scientific and technical subcommittee, specifically the working group on the long-term sustainability of outer space activities, because of a newly established expert group on space situational awareness. So when we talk about space traffic coordination, which will be really relevant to you, I am sure, it is the work ongoing here that will be important to you. Then within the legal subcommittee, we have three working mechanisms that are discussing contemporary legal issues. On the one hand, the working group on the status and application of the 5 UN treaties on outer space. We will look at how they're discussing a template to operationalize Article 11 of the Outer Space Treaty. It's all about information sharing. The working group on the definition and delimitation of outer space. This one, some might have a bit mixed feelings on it because it meets only every 2 years and has been a standing working group for more than 30 years with little to no agreement. But then we move on to the working group on the legal aspect of space resource activities with a lot of movement and only 1 more year to conclude its work, and the work outcome being principles that will hopefully be adopted as a resolution and be applicable to space resource activities. And I might be biased because I'm the secretary of the Space Resources Working Group and the expert group on SSA, but I would say those two are probably the two most active and relevant ones in the near term, because they have a very short work frame and work plan with decisions needing to be made next year. And finally, we have an action team that sits between the scientific and technical subcommittee and the legal subcommittee, and it's the action team on lunar activities consultations. And we often get asked, well, what's the difference between that action team and the working group? And we'll look at it. But in a nutshell, this is about establishing a mechanism, a global mechanism on lunar consultations for activities going to the moon. It's not about resources on the moon, it's activities happening on or around the moon and ensuring that we don't step on each other's toes. Okay, some of the topics being addressed, because there's one more, I would say, 1 or 2 more agenda items. These were the working groups that I showed you, right? COPUOS has the main committee, and then we have working groups, an expert group, and an action team. But we also have something called agenda items. Agenda items can be standing agenda items or agenda items with a specific time frame. And here I would also like to point out another emerging or contemporary issue that is within the scientific and technical subcommittee, but has a strong legal component, and that's the dark and quiet skies and large constellation agenda item, which was agreed, maybe you can say recently, but it was agreed to be put on the agenda in 2024. It was very hard fought. It was not easy to get it on the agenda. But that too, we will have a slide on it, has some I would say, implications to the legal component of space activities. Other than that, I would say all of the topics with a current legal component are discussed within specific working groups. So let's start with the legal subcommittee, and let's start with the Space Resources Working Group. So the working group on the legal aspects of space resource activities has a 5-year work plan. It was established in 2022, and it started with a mandate to study the existing legal framework for space resource activities, and by doing so, looking into potential gaps. What is it we are missing? What is it we need? When we are planning to do space resource activities, what does the Outer Space Treaty and what do the other treaties say we can and cannot do? But what is it we still need more clarity on? Where do we have a need for non-legally binding instruments or soft law to fill that gap? And what is the gap? Is it, and this is a strong point of discussion, to promote more fairness? So it's not a, first come, first serve type of activity. Whoever gets to the moon next gets access to all the resources. How can you ensure benefit sharing and information sharing across the globe? Noting, of course, that Article 1 of the Outer Space Treaty calls for equitable access. In addition, how can you ensure the protection of the environment on the moon and subsequent celestial bodies and even other areas where you might be digging for or excavating resources? That is a big point within the draft principles that are currently being negotiated. How can you put in place measures to prevent harmful contamination? This is all in regards to interpreting the obligations in Article 9 of the Outer Space Treaty. And of course, the main topic of discussion is non-appropriation. What does the principle of non-appropriation enshrined in Article 2 of the Outer Space Treaty mean? For many, it meant 15 years ago that you could also not appropriate resources. You could obviously not appropriate the moon and outer space, but to many it also meant resources. And that notion has changed over the years, with national laws allowing for the ownership of space resources by their commercial entities, Luxembourg, the US, Japan, the UAE. And now the question is, well, how far does that right to ownership go? At what point could it be considered a breach of non-appropriation under Article 2? So it is very exciting, I would say, very important that you are participating in those discussions, because the principles that are being drafted are to be finalized and agreed by next year. So the working group is planning several intersessional meetings, one per month. We're starting in September, end of September, and then leading up to April, where the legal subcommittee will meet. We're planning 6 intersessional meetings to finalize those draft principles. So please do participate in those discussions. And I believe that the outcome will be very positive. It will give more clarity both to states and commercial operators on what to do and how to do it. That's the Space Resources Working Group. Now we have another working group, as I said, on the status and application of the 5 UN treaties on outer space. It's a working group that has existed also for a very long time, but what is new is the topic that it's currently discussing, and it's discussing an article that is often overlooked, I would say, because it's probably quite far back in the Outer Space Treaty. It's Article 11. We always focus on 1 and 2 and 6 and 7, etc. But 11 is interesting because 11 is actually used. It's one of those articles that is actively being used. It's an article on information sharing. And what Article 11 says, and reminder, this is a binding obligation, it's a binding treaty. Indonesia has ratified it as well. You've ratified all 4 of the 5 treaties. Article 11 states that states agree to inform the UN Secretary General this is maintained by UNUSA, the public and the international scientific community, to the greatest extent feasible and practicable, so it's quite a soft obligation, of the nature, conduct, locations, and results of their space activities. Now, does it say what type of space activity? Does it say when it needs to inform? Does it say, how it should do this? Not really, right? It's a nice article. Some have used it. We have notifications under Article 11. They're publicly available because that is what's written here, right? It says the UN Secretary General, as I said, this is maintained by us and the public, right? So whenever we get a notification under Article 11, we have to make it publicly available. Now, what was asked by member states was, can this working group clarify what information should be shared for what type of activity? So in 2024, the working group decided to start beginning exchange of views on this, and now they're developing, and it's again very exciting work, I would say, a template that would be then offered to states and intergovernmental organizations to share information of their activities. And within that template, you'll have a list of what activities it would include, right? Is it activities that might potentially interfere with others, right? There you have also a strong connection to Article 9, where you are actually obliged to consult with other states if your activity is potentially interfering with theirs, right? So this is a way to adhere to that. You are making it publicly available, what your activity is going to do. Does this, and this is a question we often get, and I'd like to clarify it. When an activity is shared of this type of nature, we are not asking to understand the nature of the activity, be it military or civilian, for example. This is really about exploration. Are you planning to put a rover on Mars, for example? What if someone else is planning to put a rover on a very similar area of Mars? Could that potentially affect each other's activity? Could you damage each other's objects? Could you interfere with each other's signals, etc.? By doing this, at least there's more understanding of who's doing what, and one can ensure that there is no conflict ensuing out of the activity. Just to give you an example. So this is interesting, and we'll see what that template will look like. But also here, this is probably going to move towards 27, latest 28, to find agreement on the outcome. So these are just the two main mechanisms, contemporary legal issues under discussion within the legal subcommittee. The scientific and technical subcommittee has more, and again, even though it's scientific and technical, with a very strong legal component. You have heard of the working group on the long-term sustainability of outer space activities. Maybe, maybe not, but it's existed for quite some time because it's the working group that established, and it took some time, established and agreed and negotiated the long-term sustainability guidelines, the 21 guidelines that are so relevant to our activities today, that states implement into national law, thereby making it legally binding, nationally making it legally binding on their commercial operators. And now the question, and this was achieved in 2018, it was adopted in 2019, and then the question was, well, what do we need to focus on now? So what the working group focused on between 2019 until about 2 years ago was implementation. How do you implement the guidelines nationally? How do you put them into your national regulatory frameworks, in your laws, in your policies? How can you inform commercial operators to adhere to them, right? They're non-legally binding. So that was really the focus. And then member states started looking into, well, do we need new guidelines? These guidelines look into, in part, they address space traffic coordination, but very rudimentally. They address national legislation, they address space debris mitigation, they address information sharing. But the question was, do we need more? Do we need to look into active debris removal, on-orbit servicing, more precisely into space traffic coordination, into could dark and quiet skies fall into a potential LTS 2.0? So around 2 years ago, states decided to look into the possibility of additional topics that would fall under the working group, and that could be either guidelines 2.0, so an additional set of guidelines, or separate recommendations. So what happened in 2025, and I don't want to confuse here because a lot happened, but what happened in 2025 is quite interesting. We as an office, and this includes my cell phone, received quite a large number suddenly, I would say. I mean, that has happened for a few years now, but 2025 was really a year where it happened more than ever before. We received a large number of calls, either, as I said, my phone or the phone of the director, by national regulators or commercial entities that were in danger of their satellite colliding with another satellite, and they had no way of communicating with the operator of the other satellite. So why did this happen? Either it was because it was, on the one hand, a governmental satellite, and on the other hand, a commercial satellite, and there was just no communication channel. And since this was happening in low Earth orbit, and maneuvers need to take place within at least 12 hours, if not less. If this happens in geostationary orbit, we have a bit more time, right? We have a few days, a bit more time potentially for maneuvers, but in low Earth orbit, things can go bad very quickly. So two scenarios here, as I said, either we had a governmental operator calling us saying, oh, we can't get a hold of a commercial operator. By the time we reach the regulator, right, the national entity in charge for space, so that they can contact the commercial operator, time's up. Do you have the contact details of this commercial operator? That was one scenario. Or another scenario, it happens, is two government satellites, but no diplomatic ties. They don't speak with each other, right? For political reasons, whatever. And here too, of course, we're the UN, we're supposed to, and we are the neutral party, and we're happy to provide those diplomatic channels. It's what we're here to do. However, time is the issue here. The one case happened, in fact, I was on the way back by plane from a mission in Ghana, helping them establish their space agency. And I just had a layover in Brussels, and then the phone got called. And the point is, this is not a solution. We are a very small office. We cannot be a hotline for two potential very dangerous collisions in low Earth orbit. So we were able to present these examples to member states last year, and there was already a growing awareness about the importance of the need for more coordination in regards to conjunction risk. So more coordination in regards to satellites in orbit. How do we coordinate our maneuvers? How do we communicate? Do we have some type of platform where we can access each other's information? Can we know who actually operates what? Yes, we have the UN Register of Objects Launched, but it doesn't specify who actively at this very moment operates the satellite, has actual control over the satellite, right? The flight dynamics team behind the satellite. So there was already raised awareness about this issue. And with these examples that we were then openly sharing with member states agreed to establish under the working group on the long-term sustainability an expert group on space situational awareness. And I'm a lawyer, and I understand that this topic sounds very technical and I'm asked to cover the legal contemporary issues, but it has a legal dimension because space traffic coordination is the first step to space traffic management, and space traffic management is legal, it's policy, right? Space traffic management is where we will translate the technical space traffic coordination requirements into national regulatory requirements. You, as the regulator, as the entity in charge for space, will at some point require from your operators that they share point of contact, right, with the global space community, or that they share ephemeris data, etc. That's where we have the legal component, that's space traffic management. But we're starting with space traffic coordination because we first need to know what is it that operators need? What information do they need to be able to ensure that their satellites don't crash into each other? So this expert group was established, and let me tell you, I don't think I've ever seen Corpus act so swiftly. The expert group was established last year in June, and already within 1 year, we have actual outcomes. And we actually, and this will be the next slide, now have a hub that will be launched in the next few days, which will enable global space traffic communication. And we'll see what that means. So what has happened since the establishment? It was established, as I said. What is different here is that industry, so commercial operators, are involved. And this is very unusual for Corpus, as you might know. But what was decided is that industry can be part of the national delegation. So we see, for example, Amazon Leo being part of the US delegation. We see Eutelsat, a big French operator, being part of the French delegation. We see Germany bringing on board operators, and more we see, in fact, commercial operators as part of the national delegation, because it's not necessarily, I'm not saying this is the case everywhere, but in many jurisdictions, we see that it's more commercial operators operating satellites than governments. So they need to be part of the discussion. So what was done is that a survey was sent out to all Corpus member states to understand what is the minimum data, the minimum information you need for conjunction, for avoiding collisions. And the minimum information, there was a long list, and we will work on it, and we will find agreement hopefully by next year. But what we already found a preliminary agreement on is one low-hanging fruit. It's point of contact. It's what my phone and the director's phone is being called on, is how can I contact that other operator? So what happened is now at Corpus this year in June, minimum information was identified. Point of contact was identified as the bare minimum, and a set of recommendations, which then hopefully will be translated into national regulatory systems, will hopefully find agreement next year. But because of the discussions that happened now, the UN has been tasked to launch something called the United Nations Satellite Operator Contact Hub, UNSOC in short. And you're one of the first, I would say, to hear about it, because it's just about to be launched any day now. And it's exciting, and we really hope that Indonesia participates as well. It's of course voluntary, but it's operationalizing guideline B1 of the LTS guidelines and the minimum information required under the discussions that were happening now within the expert group. It is a hub for both national regulatory authorities and operators and this is not supposed to be a space traffic coordination tool. This is purely the second to last word here. It's contact. It's about contact details. It's about having a 24/7 available telephone number and email address of the entity operating the other satellite, so you can contact them in case of collision, right? So it's about one trusted place. It's the UN to contact whoever is in operating a satellite, any satellite. What we do is we vet every operator. We ensure that whoever is putting their contact details in there, in fact, is the operator of a specific satellite. So we do these checks. We do these checks together with the UN Register, but also together with national regulators. We will reach out to the permanent mission, of course, if we have questions whether this is in fact one of your operators, etc. So that was all on the expert group on SSA. One more thing to add. This happened within 1 year. We were able to establish this United Nations Satellite Operator Contact Hub. But what is going to happen next? Now the expert group has until 27, 28 to hopefully come up with a global mechanism on space traffic coordination. Global mechanism, meaning you have every operator, governmental, commercial, sitting around a table under the auspices, of course, of COPUOS, of the UN, and discussing what information they're willing to share, because, of course, a lot of information they're not willing to share, and that is fine. That's the purview of states and commercial operators. But what information at a minimum are they willing to share to ensure more safe operations in space, less potential collisions? And two more topics, two more emerging legal contemporary topics. And this one I would have liked to have placed right after discussing the Space Resources Working Group, but it doesn't fall under any of the subcommittees. So it's here now, it's placed here in the slides. It's the Action Team on the Lunar Activities Consultations, ATLAC. And I double checked with my colleague. Indonesia has nominated members to ATLAC, in fact, last year. Currently, 54 member states have nominated members. And this is another one of those working mechanisms of COPUOS that it's such an exciting time to be participating in COPUOS, because here too, the finalization of its work will happen next year. And the outcome of the work is really exciting. So it's all about topics around safety of operations and coordination needs for lunar activities. Why was this established? Because member states informed us that they're planning a lot of activities on the moon in the next 5 to 10 years. More actors than before, right? When we look back to the activities on the moon back in the 60s and 70s, we had 2, maybe potentially at some point 3. But now we will have 5 or 10 different actors, including governmental and commercial. And the moon, as big as it seems to be, the area where the activities are taking place, so the South Pole of the moon, where there's potential for water or ice, in fact, that could help us develop moon bases and create oxygen and you know, some type of living environment, so that we can then at some point get to Mars, etc. All of these fantastic ideas that engineers have. It's not such a big area, right? And we always need to ensure that's at the core of the work of COPUOS. We need to ensure the peaceful use of outer space. So how do you ensure that these activities are coordinated, that we don't step on each other's toes, that we remember we all use different type of technology as well, technology, equipment, and we're planning to bring humans back on the moon. So it's important that we don't have very negative consequences. So that's where this is coming from. And it's about coming up with again here, a mechanism for consultation. How can states that maybe don't always talk with each other consult with each other? as part of the COPOS framework of mechanisms to do so. And finally, dark and quiet skies. Personally, I would say one of my favorite topics. I'm not sure. I do believe, no, in Indonesia does always, I think, have a moot court team as well for the Manfred Lech Space Law moot court. I drafted the case a few years back, which was about dark and quiet skies. So yes, it's very relevant to me, and it has a strong legal component to it, right? Yes, dark and quiet skies in general is about protecting the night skies from pollution, from light pollution. And who really brought this topic to the table? Well, it wasn't lawyers, it was definitely astronomers, right? It was the astronomical community that petitioned the UN specifically to act. It had been doing so for many, many years. It took the UN quite some time, and with the UN, I also have to say we can only act when member states want us to act. But it took some time to find agreement on this specific topic. And why was this important? Well, their scientific freedom, the freedom for scientific investigation, was being impeded. They, or the astronomical community, was saying that their telescopes, both ground-based, but even those in space-based telescopes, were being impeded by light pollution. So you were taking images, and we can look at this image here, and the images you saw were just light streaks, and these light streaks were satellites. It's the light emitted by satellites. Either it could be light emitted by the satellites themselves because they have light on board, or more usually it's light, it's reflection from the sun, and so forth. So here a big push came from Spain, Chile, even South Africa. Why? Because of course they have a lot of ground-based telescopes within their jurisdiction. And in 2024, it's written here 102 states, that's how many states were member states of COPOS back then, agreed to make an agenda item running from 25 to 29. And it's discussing optical brightness first and foremost. Radio frequency interference and with radio observatories is also a topic about dark and quiet skies, but that is covered by the International Telecommunication Union. So we're both working on the topic of dark and quiet skies. That's why we are coordinating closely on it. But from our perspective, it's about the object itself. It's the optical brightness. And from an ITU perspective, it's the radio frequency interference. So in 25, we convened a workshop with SCAO on dark and quiet skies. We did a whole day on the legal aspects of dark and quiet skies to look into how some states already in their national legal frameworks, in fact, regulate the issue of dark and quiet skies, meaning they require from their operators that mitigation or technical requirements are put in place to mitigate any effects on the skies. So, for example, using coating material that does not reflect the sun, right? Or ensuring that that there is no light being emitted during specific phases of an operation, because where satellites emit the most light is in fact when they're being deployed. It's when it disturbs telescopes the most. So all of this, some states already include this in their national framework. So we were looking into how can more states do this? How can it become a global guideline, right, for states to do? And this year as well, in December, we'll do a similar workshop. So hopefully these workshops are mostly here for you. They're actually for member states, so that you can then discuss this topic as an agenda item with more awareness about what can actually be done. And it has until 29 to do so. So another one I would say, which is quite contemporary and where we need to find solutions because this is impacting the scientific community. Okay, I'm just taking a peek at my clock, and I know we're slowly but surely running out of time because we also have a Q&A session. So Alif, if I may, can you let me know whether I should still do a few minutes about some of the contemporary issues outside of Corpus, but based on international space law, or we jump into the Q&A? I'm in your hands.
We still have 10 minutes before the Q&A.
All right, excellent. Very good. Happy to hear. So I covered in general, I would say the current topics at Corpus that are currently being discussed. But just because a topic is currently not being discussed at Corpus doesn't mean it's not a contemporary issue, because of course there are a lot of contemporary issues that are already being dealt with by the treaties. The treaties had a lot of foresight in the 50s and 60s. The treaty drafters had a lot of foresight. And not what we see now is that some of the key principles in the treaties are actually being, and I love this word, operationalized. They're coming to life. They're coming to life in a way that maybe was not expected originally, but they're being used. And I want to share maybe one or two examples of how it's being done. The most common one that we see is, in fact, the Rescue and Return Agreement. And it's an agreement that many did not believe would be coming to life anytime soon, but it is, not because of the first half of the treaty, which deals with astronauts, but because of the second half of the treaty that deals with space objects. Space objects landing in foreign territory. What do you do? Who do you contact? And do you have a right to compensation? And we'll see how this is actually happening a lot. But we take a step back. Some of you might have never heard of space law. So very, very briefly, why did we need space law? Well, we needed space law, as I said, because satellites were being launched. Humans were then at some point also being put into space. And we needed to ensure that the Cold War, because we were in the middle of a Cold War era, that the conflicts here on Earth were not being just put into space, so preventing outer space from becoming an area of conflict. Of course, it's always about strengthening international cooperation, but at the core, it's also about distributing the benefits between states. It is not a first come, first serve. It's not a Wild West. So we have here the 5 treaties. As I mentioned before, Indonesia having ratified the Outer Space Treaty, the Rescue and Return Agreement, the Liability Convention, and the Registration Convention. So congratulations, that's fantastic. And then we have a set of principles that are, and here I want to put maybe point out on something, because I get asked to do so many interviews lately. I would say there's a lot of interest in space, which is good. But there's a lot of misunderstanding. The question I get all the time is, aren't the treaties outdated? Don't we need a new treaty? Why is nobody agreeing on a set of treaties, binding treaties? Why all of these principles and non-legally binding instruments are soft law? Well, treaties take a lot of time to negotiate, and they're binding. They're supposed to live for a very long time. Space is a very technical field. Technology evolves all the time, right? Every year we hear of new technology. Now they're talking about space data centers. Tomorrow they'll be talking about probably robots on the moon. I don't know. It will be something, right? And we cannot have a treaty deal with these issues because it will not live as long as the technology will live, or the technology will always outrun a treaty. So what the treaties did very cleverly is that they are very high level. They have high level principles that will be applicable to any type of activity, right? Whether it is an AI activity, it's a human activity, whatever activity, we will be able to use the treaties because they are drafted in such a high level way. It's high level principles. And then we use non-legally binding instruments, such as principles, such as guidelines, such as recommendations, to interpret those principles, to interpret those obligations. What does it mean to act without harmful interference, right? What does it mean? Well, we look at guidelines, we look at recommendations, and we see, this is what's recommended by not interfering harmfully. Or we say, well, what does it mean to authorize and supervise an activity? As a state, I have an obligation to authorize and supervise activities under Article 6. Well, it means that they have to adhere to, for example, the space debris mitigation guidelines or guidelines within the long-term sustainability guidelines. So these are technical requirements that need to be very flexible. We need to be able to adapt them, to change them as technology evolves, but we don't want to touch the treaties. So I would say the treaties are not outdated. I would not say that we need a new treaty. What we need is more technical requirements that we have to interpret the treaties. So the Outer Space Treaty is from 1967, and it's a framework treaty. It establishes some core principles of international law. As of January this year, we have 118 ratifications. That's very good for a treaty. And most importantly, however, it includes all major spacefaring nations. These are the core principles enshrined in the treaty. You know, we have the exploration and use of outer space should be free to all, right? It's a right. So the treaty begins with a right, not an obligation. And then we continue on. Non-appropriation, important. I mentioned it already with the Space Resources Working Group. We have peaceful purposes, versus military use versus aggressive use of outer space, and so forth and so forth. We'll just look at maybe 3 of them because of the contemporary nature of those articles, and then briefly jump into the Rescue and Return Agreement and then Q&A. But Article 2, as I said, and I mentioned it already in regards to the Space Resources Working Group, conveys the non-appropriation principle. So it's an obligation. It states that states may not claim sovereignty, occupy territory, or establish ownership over celestial bodies. Does it mention resources anywhere? No, it does not. So that is really where now the contemporary issue, space resources, because that is becoming an activity that is becoming possible, right? We have technology that is able to start utilizing resources and extracting resources. So it's clear to all, and it is undisputed, it is clear to all that you cannot claim sovereignty in outer space. You cannot go to the moon and put your flag there and say the moon is mine. And why did they do this? I mean, maybe it's clear to you, but maybe not. I mean, it is because they didn't know who would get there first, right? They just didn't know back in the 50s when this was discussed. There were 2 possibilities. It was either the Soviet Union or the US, but neither knew who would be there first. So better than losing to the other, potentially losing, I mean, one lost to the other in a sense of who got to the moon first, but losing property to the other potentially, or sovereignty over the moon to the other. They decided no one can own it. And of course, the Global South pushed for this as well. But I just want to be a bit of a realist here that of course, at the core as well was this worry, who gets there first owns it first. We're not sure who will, so let's make sure nobody can own it. So that is the core of non-appropriation. You cannot claim sovereignty. You cannot occupy territory, right? And you cannot establish ownership. So when you, for example, buy a star on the internet, unfortunately, you do not have ownership over that star. But the question around resources continues, and that's what the working group is discussing. One more, peaceful use versus military use. Here too, sometimes misconceptions, I would say. The Outer Space Treaty is very clear that the outer space may only be used for peaceful purposes. again, questions I get often from newspapers is, well, but space is used for military purposes, and isn't that a breach of the Outer Space Treaty? Peaceful purposes does not mean non-military. Why? It is clear that even from day very one of space and the use of space, military use was there. The first satellites being sent to space were military. The first humans sent to space were military. They were, soldiers. So military use was always there. Peaceful use does not mean non-military. Peaceful use means non-aggressive. You cannot use space to attack, to purposefully destroy someone else's property, right? And specifically, there are very clear prohibitions. You may not place nuclear weapons in outer space. You may not place weapons of mass destruction in orbit or station them or install them on celestial bodies. And again, outer space, the moon and celestial bodies shall be used for exclusively peaceful purposes. Yes. Military uses, fine. Yes. Dual use is everywhere. Most satellites are both military and civilian. I'm not saying all, but many. But what you cannot do is you cannot use space aggressively, right? You cannot breach, for example, the UN Charter, because the UN Charter is also applicable to outer space activities. And finally, I'm checking the time, apologies. One more, but this is important. States, and this is important when we talk about the commercial use of outer space, because again, a question all the time, yeah, but the treaties, they don't apply to commercial entities, Elon Musk, Jeff Bezos, this does not apply to them. Well, that's not quite correct because we have Article 6. Article 6 says two things. It says on the one hand that states are legally responsible, right? It doesn't say legally, but this is what responsibility means. States are responsible for national space activities. So what does it mean? I have a company, let's say in Austria. I'm a private person. I'm launching a satellite or a constellation, thousands of satellites. I am a national of Austria because my company is here. Maybe I would even be an Austrian national as a person as well, but no need for that. My company is here. It's a national space activity. Austria would be legally responsible for that activity. So the US is legally responsible for the activities of SpaceX and so forth. And in addition to being responsible for the activity, meaning in case of a breach of international law, they would be legally responsible, states also have to, and here there's explicit mention of non-governmental entities, equally so in regards to responsibility, states must authorize and supervise activities of private actors. So before doing an activity, you need to receive the authorization to do it as a non-governmental entity. So this is very important, and this is the basis for national space legislation. And one more thing, and Alif, I'm so sorry. If you give me 2 more minutes, I'll be done. But this one is so exciting. It's the Rescue and Return Agreement because it's one of those treaties that nobody knows about, and it's actually being used so much. It is 100 ratification. It's the shortest of all of the 5 treaties. It has 10 articles. And we're not talking about, as I said, the first part, we're talking about the second part, because the second part deals with space objects. And why did we need the Rescue and Return Agreement? Again, Cold War. The biggest worry was my cosmonauts or astronauts or space objects land in hostile territory, right? They might become prisoners of war. My technology might be used potentially to learn all my secrets, etc. So it's often called a humanitarian agreement. It's about helping astronauts in distress. Yes, it's true, but it's also, and again, realist here, it's also about ensuring that I get my property and my astronauts back. So when my astronaut or my object lands in foreign territory, I have a right to get them back. And if it's an astronaut, countries have to do everything in their power to help them. But when it's an object, and we will focus on objects, there are two things that need to be done. And it's happening a lot in Southeast Asia, but it's also happening a lot in the African region and the Latin American region. You find an object in your territory, you have to do two things. On the one hand, you have to notify the launching authority, it's called in this treaty, and notify the UN. And we, UNOSA, maintain that list of notifications. And if the launching authority wishes to have that object back, you need to help ensure they get it back. But now comes a point that is being used more and more. If you help recover their object because it's in your territory, right? They cannot just enter your territory and take it. It's your jurisdiction after all. You help get the object back to them. You have a right to compensation. You have a right to compensation for all of the costs incurred. And what's happening is that this is happening more and more. We are receiving more and more both official and unofficial notifications of objects found in territories. Unofficial, what does it mean? Unofficial because either the notification hasn't been done yet or because they haven't ratified the rescue and return agreement, so they have no official way of notifying, but they still notify us. And we help. We help put the two countries in contact with diplomatic channels. We also help share understanding to you of what your rights are under the treaty, how you can claim for compensation, and so forth. And we also help identify the object. This is, for example, what we also did in Kenya. So these are some recent examples. There was a big chunk of an object landing near a Kenyan village in December 2024, very close to a village. Legal proceedings internally, by the way, are still ongoing here. The case in Poland was quite interesting as well. It was nine pieces of debris or space objects scattered across Polish territory. It could have hit I think it's 12 different jurisdictions in Europe, and the Polish case is an interesting one. This was in the news, so I'm not sharing anything I shouldn't be sharing, because the day after it happened, the Polish Space Agency Director General was fired because the internal procedures for raising the alarm of a potential impact were not clearly in place. The email address that the information was sent to didn't work, etc., etc. So this example shows important to have in place internal procedures to coordinate in case of these types of things happening. So I hope this was interesting. I mentioned these just because it's very contemporary in a sense. They're happening more and more. And I will not cover the liability convention, but you have it. I also have some information on the register of space objects launched into outer space with the number of objects, with the number of states having launched a satellite and all of the registrations we receive. And it's a very large growing number of registrations. And then there's a bit of information on the Space Law Project. But as I said, happy to share all of this information. Maybe just the last slide, and see, it is the last slide. If you want to know more of space law, and I know you have a fantastic webinar series, so probably you don't need it, but if this is very interesting to you, we have e-learning modules that are openly accessible and free to all. We have 4 modules on space law, 1 on space economy, and 1 on the long-term sustainability guidelines. So if you just do UNOSA e-learning, you'll find them, and they're in English, French, and Spanish for now. And then we have the ASTRO database, which is a collection of all national laws and policies. So this is maybe useful if you're drafting your master's or your PhD, or you're in the process of revising your national law and you want to see how others do it. Then the ASTRO database is useful for that. So thank you. I'm really happy to take questions. And again, a huge thank you to Alif, the moderator, and of course to Indonesia for having me.
Thank you, Rosando, for your very enlightening materials and very in-depth as well, starting from the processes inside the UN COPOS as well, aided by the UN OSA, including development and contemporary issues um, outside of the institutional level as well. Now, I invite the participant of the webinar to ask questions relating to these contemporary issues. Maybe while waiting, let me start with the opening questions. Probably something that maybe Indonesian scholars are wondering why the UN COPOS mechanism retains the consensus, specifically since the consensus itself creates it harder for us to create new treaties, and we are moving on to more technical guidelines and recommendations. So why does the UN COPOS decided to retain the consensus mechanism?
Sorry, forgot to mute myself. Very good question. And I mean, I'm not a member state, so you have to ask Indonesia why you're retaining consensus. But I would say it would be very difficult to remove it. To remove consensus, first of all, you would need consensus, right? This is a decision that would need to happen at the General Assembly level. That's where COPOS was established. And also, I would find a shame. I would really find it a shame if it were removed, because let's say you remove consensus. Yeah, you start drafting treaties, you adopt them with a vote. You only get a small majority, but you're still able to adopt them. And then what do you have? You have a treaty with no buy-in, with very little agreement found in the room, and nobody's going to ratify it, right? And then you have an empty shell at the end of the day. I mean, a bit similar to what we had with the Moon Agreement, unfortunately, even though, and that's the paradox I find sometimes with the Moon Agreement, that all COPOS member states agreed to the Moon Agreement, otherwise it wouldn't exist. It was adopted by consensus, but we only have 17 states that have ratified it. So, some call it a failed treaty. And my assumption would be that if we remove consensus, that something very similar will continue happening. You'll have potentially treaties. Okay, that's great, but it will not have any impact at all. What consensus helps with, however, and that's what I mentioned before, is you have these treaties with high-level principles. What you need is technical recommendations to interpret the principles. Because do we need new treaties? I don't think we do. I think we need more technical and also legal recommendations to interpret the obligations we have. But thanks to the mechanism of consensus, we have a very strong buy-in at the end of the day once it's agreed. Again, if you only have a set of countries in the room, a bit more than half, agree on it, what about the rest? And probably the rest will be those with the largest number of satellites, It won't have the effect that you want to have. So I personally, and from UNOOSA perspective as well, we see consensus being very, very important in the way that COPOS takes decisions.
Thank you, Rosana, for your answer. Since you already mentioned the satellites, specifically the number of small satellites being launched in the outer space. So, has there been any cooperation between the UNOSA and COPOS with the International Telecommunications Union, for example, to at least to agree on a set of technical or legal recommendations in order to keep space equitable and accessible to all of the member states of the COPOS?
It's a very good question again. And of course, we work closely with the ITU. In fact, I have so many hats to wear. It's because we're such a small team, but it's also me representing UNOSA at the ITU's meetings in Geneva. And the issue of equitable access is, of course, a difficult one because you have two rights, or you have one right and one obligation in a sense that will be important to note here, and they're both in Article 1 of the Outer Space Treaty. On the one hand, you have the freedom to use and explore outer space. Thereby, and I see His Excellency, you have your hand raised. I will keep my answer short, but you have this freedom. So this freedom does not denote, or it does not include a limit. It's not there in the treaty, right? It doesn't say you have the freedom to explore and use, but only with a specific number of satellites. What it then does, however, say is the freedom to use and explore and open and accessible to all. So that's the equitable access notion. So here again, it is up to COPUOS and member states to agree what and how equitable access can be achieved. Currently, and I work a lot with engineers, thankfully, as I said, I am not one, but I am told that equitable access is not yet in danger, in fact, not in LEO and not in GEO. So, I mean, we're not there yet, but it is good to ensure that the discussions are happening, to ensure that you will continue as emerging spacefaring nations have access to space, especially as we look at plans around, and I mentioned these before, space data centers. We hear of potential plans of hundreds of thousands of satellites being launched to enable these. Will equitable access then potentially be in danger? Maybe, but it's up to member states to discuss it. But when they do discuss it, we of course notify the community in Geneva, and vice versa. The ITU notifies the community in Vienna at COPUOS. So we ensure that these discussions are coordinated at all times.
Okay, thank you for your answer. Now I invite Your Excellency Pak Damus to deliver your question.
Sorry, Madam Home, I'm not intending to interrupt you on the satellite question. I just want to refer to the first questions raised by Alif about consensus, the importance of consensus in Vienna. I just want to add something that perhaps to add your comments. In Vienna, we have so-called Vienna spirit. Vienna spirit is a kind of what so-called member state always take decisions on the consensus manner. I mean, in Vienna, actually the issue being discussed here is more about technical issue, legal issue, scientific, and something that normally we don't need any so kind of voting procedure, because we are talking about the common sense, about the common interest of state. So that's why in Vienna, normally, I'm talking about in the past, normally we always come to a consensus when we are dealing with something that common interest of the human being and of the international community. But in the recent situations, when we are talking about outer space, for example, now come politicization, come about the political interest, and sometimes it is not derived from the issue itself, but sometimes it derived from other issue, which is, for example, like Ukraine issue, about the new policy in other issue, and then it become being dragged into the outer space issue, which is not the issue of the outer space itself. So this is why some concerns coming always from the scholar, from international, what we call it, from international civil society. Why now in Vienna you are talking about something with consensus? Because consensus sometimes hamper the process rather than speed up the process. So now, Pak Alif, there's also a new development now in Vienna. So I have a dream to put back Vienna in the past. I mean, because in the past we are always talking about technical issue in the technical manner rather than put politicizing in the issue. So about, for example, about the voting procedure, Indonesia and developing country is ready actually to go for voting because Indonesia and developing countries the majority. But Indonesia is not keen to propose the voting procedure because we like to be consensus. I mean, we like consensus is always the good one. So, for example, the recent product that we have produced in consensus in the Cybercrime Convention. So, you know, in the Cybercrime Convention, there's many differences from the political perspective, but we still have common interest in the Cybercrime Convention. So we can conclude the treaty through consensus basis rather than voting procedure. So I in line with you. So we need to keep the consensus basis as long as possible. But on the other hand, we need also to encourage international civil society to put weight to the process. Hey, look, this is not only the interest of one or two states, but this is the interest of the common heritage of mankind. So let's do it in that way rather than to inject or insert your political agenda in this kind of common heritage treaty. So that's my opinions on this, Madam Hopman. Perhaps it will enrich the discussions about the consensus problem. Thank you, Pak Alif.
Thank you, Pak Damos, for your member state perspective. So that we need to keep the consensus in order to ensure the development of the space law and policy. So coming back to the materials that you've given us, I noticed that there is more focused on lunar exploration. I believe there is this action group, if I remember correctly, mentioned. Is this made as an answer to extra institutional effort outside of the UNCOPOS by the US, for example, like the Artemis Accord made by the US to establish a governing principles for them and their members or their allies. And is this lunar activist action group is UNCOPOS trying to answer? Possibly there are some different positions that the UNCOPOS will have to take between the COPOS and as well as the Artemis member states.
Thank you for that question. And first, I have to, of course, thank His Excellency Ambassador for the additions made in regards to consensus and the Vienna spirit. I couldn't agree more. I hope also to go back to the original Vienna spirit very soon. And yes, right now the discussions are highly politicized, and unfortunately, for example, we have not yet, in fact, even agreed to a COPOS report. And his ambassador, His Excellency, and also Mia from the Permanent Mission very well know that we're still working hard on that issue. So yes, all I can say is hopefully back to the Vienna spirit. And to add, and then I'll answer your question, to add that to what I had said before already, but building on what His Excellency said, because of the human heritage component and the fact that space affects us all, right? Security, health, I mean, we rely on space so much. We need everyone to agree. If we only have a majority of the room to agree and the rest just disregard what is being discussed, this will be detrimental to this type of activity. It might be different in other areas being discussed, but especially when we talk about space, issues around, as His Excellency said, common heritage, but space and even the high seas and so forth. We need to have consensus. But on your question on ATLAC and the moon and Artemis Accords, and I would even throw in ILRS into this discussion. Yes and no. You asked whether the discussions at COPUOS are, in a sense, an answer to what's happening with Artemis. What's happening at COPUOS, and it's not just ATLAC, right? There's also the Space Resources Working Group, and I would say they're equally important when we speak about the moon, is that there are now a lot of activities planned to the moon. You might know that for many years, the moon and activities to the moon were not happening. I mean, it was really, we're talking 30, 40 years here of potentially no activities to the moon. So there was no need to discuss this. Now, the Artemis Accords, ILRS, but also a lot of national initiatives, more so than ever before. Also in your region, but of course in the US, and of course in China, and of course the Russian Federation, but also others, India, Brazil, believe even Indonesia, if I'm not mistaken, are potentially planning missions or are part of some type of missions to the moon. So that's why the discussions took on a new momentum. And what happened with the Artemis Accords is that the Artemis Accords are, of course, a political declaration. They're not a legally binding instrument. They're not replacing the governance work of COPUOS. They are reiterating the core principles within the Outer Space Treaty. And we even did a workshop 2 years ago where we compared, and we invited, of course, all of the delegations to participate, where we compared the ILRS and the Artemis Accords and the Outer Space Treaty and Moon Agreement, etc. And we saw there is nothing that is in any way or form contradicting each other. It's a declaration that reaffirms a lot of the core principles. Now, this declaration is used as a basis for activities leading back to the moon and the Artemis program. And because of that, because of all of these activities, member states said we need two things from COPUOS. We need, on the one hand, to know, and this is what the working group is doing, we need to know what we need to do and how we need to do it when we do an activity on the moon. So when we excavate resources, do we need to share it with everyone? How does it work to share? Do we share it physically with, for example, developing countries? Or do we share the financial gains, or do we share the scientific information? How do we share, right? Or when we start digging on the moon, how do we ensure the environmental protection of the moon? Do we need to put everything back to place after we do the digging? How much can we dig? Can we have safety zones? That's a huge issue, right? All of this is what's discussed within the working group. And then ATLAC, as I mentioned, is discussing the coordination of activities. If the Artemis program is planning an activity and ILRS is planning an activity, how can we make sure that they don't, step on each other's toes and potentially damage each other's or interfere with each other's activities? And that would definitely lead to conflict. So that is what ATLAC is doing, right? It's about coordinating, it's about consulting with one another before the activity, while Space Resources is saying how to do the activity, what can you do, how you should do it. And it's very, very exciting. But I would say that originally when the Artemis Accords came out, very at the very beginning, and I remember it clearly because it was mid-COVID, and I still worked for the European Space Agency back then. And then, we were all in shock because we said, well, how can you now come with this unilateral approach to the governance of the moon and activities to the moon? But then when you look into the accords and you see it's a political declaration, it's not a binding MOU or something like this, and you see it reiterates, in fact, only what the Outer Space Treaty states, it was the community calmed down again. Yes.
Right. Thank you, Rosanna, for your answer. Are there any further questions from the room? I invite everyone. to ask a questions. On the chat box, there is questions that someone in here dropped to me personally. Would you like to deliver it your own? I believe this is one of the teaching assistant here. Rashid, or should I read it on behalf of you? Okay.
Hello.
Yes,
If admissible, I can try to ask myself.
please ask your question.
Okay, thank you very much, Bang Alif, for the opportunity. So, in relation to the previously presented materials, given that I also have a personal question related to the Outer Space Treaty. So, given that Article 9 lacks the explicit thresholds on enforcement mechanisms, how can the international community objectively measure state compliance with the due regard principle when balancing the national, commercial, or security space activities against the collective state interest related to safety or the environment? For example, also those relating to the selection of specific materials for constructing the satellites or any other space equipments that can also affect how satellite imagery can be captured. How can this principle play a much more vital role in regulating space activities then? Thank you.
Thank you very much for that question. And look, I'll keep my answer short, but the question is like a PhD question, and I'm sure you know it. It's you can write 400 pages on the principle of due regard, and now you put it in connection with satellite imagery and satellite manufacturing and materials and threshold of enforcement, et cetera, et cetera. So it's a very broad question. So please bear with me when I'll just summarize it briefly. So there is, of course, no, as you know, definition to the principle of due regard, but, and here I come back to the non-legally binding instruments and actually their extreme importance, and oftentimes this is overlooked. Due regard, including the principles of, harmful interference, consultation mechanism under Article 9 as well, etc., are being interpreted, and they are supposed to be interpreted with the subsequent principles and guidelines that have been developed by COPOS. And you're an academic, so I can go as far as to say that, for example, the International Court of Justice in the whaling case specifically confirmed that non-legally binding instruments developed by the same treaty-making body that developed the treaties are to be used to interpret treaty obligations. So this is a clear standing decision by the International Court of Justice. So what does that mean? You have the space debris mitigation guidelines, the long-term sustainability guidelines, the remote sensing principles, and I'm just trying to cover some of the topics you mentioned, right? Remote sensing principles in regard to Earth observation imagery, the long-term sustainability guidelines. You'll have some aspects relating to material for satellite manufacturing, etc., that should be used to interpret what due regard means. So adhering to these non-legally binding instruments means you reach the threshold of due regard. In summary, yes, of course, all of this needs to be looked at case by case. And as I said, 400 or 500 pages of a PhD should be written about it to look at it precisely. But in general, that would be my answer. And the current recommendations being drafted both within the expert group on SSA, but also other mechanisms, specifically the one I mentioned, the working group on the application and implementation of the 5 United Nations treaties with the template, are actually looking at the notion of due regard. By sharing information of the activity, are you acting with due regard to the interests of other states? So, and then finally, on your question of enforcement, and also here, Of course, you know very well that international law and enforcement are a difficult concept in general. We do not have police in outer space, but what we have are national regulatory authorities. They are the enforcers, right? So it's up to national regulatory authorities to enforce the treaties and the non-legally binding instruments on their commercial operators. And if they themselves, if states themselves don't adhere to it, they will, of course, be politically at Kopos, criticized openly. And what we've seen so far, thankfully, is that enforcement has not been needed as such, because states are in fact adhering quite strongly to the treaties, including to some degree, the notion of due regard. Why? Because if they do not adhere to it, their own space assets will be in jeopardy as much as others, because of the hazardous nature of space. So it is the self-preservation aspect of space law. So Rashik, I hope I answered your question somewhat, but it's a very good one, and I'm sure that you are researching it in detail.
Thank you, Rosanda, for the answer, and Rashik for your question. I believe that is the last question that could be asked. I'm sure that thousands of questions will be asked if I do not limit it, and we will have like 30-hour seminar or something. But maybe that is also something to think on, and probably something for us to possibly invite you to Jakarta to give further lectures in space law issues. Maybe before I hand it back to the MC, let me conclude by putting several notes that I take from the material given. Specifically, the contemporary legal issues of the UN Kopos is heavily influenced by the processes inside the Kopos itself, and also issues that possibly raised by the Office of Outer Space Affairs. And these issues are currently mainly including the lunar exploration, space resources, sustainability, and space traffic management. And also there are issues on space debris, space traffic, and space situational awareness. Of course, if we want to unpack each of these issues one by one, we need to have further discussions. So that would be the end of our discussion this afternoon or morning in Vienna. Thank you, Dr. Rosana Daim-Hofmann, for your time giving the material, and I return the time to the MC, Ibu Paradia.
Thank you very much, Mr. Alif, for guiding today's discussion. Our sincere appreciation also goes to Ms. Rosana for your highly informative presentation and for providing valuable clarification in response to the question raised by our participants. We shall now proceed to the closing remarks for this webinar, and also joining us is Mr. Widya Rahmanto, our Secretary of the Director General for Legal Affairs and International Treaties of the Ministry of Foreign Affairs of the Republic Indonesia. For the closing remarks will be delivered by Pak Widya. Pak Widya, may we kindly invite you to deliver your closing remarks.
Thank you. Thank you very much. Good morning, Your Excellency Ambassador Damos Agusman, Indonesian Ambassador to Vienna, and also Ms. Rosana Daim-Hofmann from UNOCA, and also good afternoon, Prof. Ari, and also colleague from ISIL and all Indonesian participants. As we come to the end of today's webinar. Allow me, on behalf of the Ministry of Foreign Affairs of Indonesia, to express my sincere appreciation to Ms. Rosana, and also to all participants. We are truly grateful for your willingness to share your expertise and valuable insights on the latest developments within the UN Committee on Peaceful Uses of Outer Space, particularly its legal subcommittee. I will also like to extend my sincere appreciation to all participants for your active engagement throughout today's discussion. The quality of the question, I believe, has demonstrated the growing interest among Indonesian stakeholders in international space law and policy. I believe also your participation has contributed to the success of this webinar. Indonesia, as an active member of UN Corpus, attaches great importance to the continuous development of international space law. We firmly believe that outer space should remain a domain used exclusively for peaceful purpose and for the benefit and in the interest of all countries, irrespective of their level of economic or scientific development. In this regard, strengthening national understanding of contemporary legal development in outer space governance is becoming increasingly important as space activities continue to expand in both scope and complexity. I'm also pleased to note that this webinar has successfully achieved its objective of enhancing participant understanding of contemporary developments in international space law, while strengthening networks among our distinguished speaker, the government of Indonesia, and all participants. Today's discussion have underscored the enduring importance of multilateral dialogue, transparency, capacity building, and international cooperation in ensuring that the exploration and use of outer space remains safe, sustainable, peaceful, and consistent with international law, in which UN Corpus will play a significant role. Before concluding, on behalf of the Ministry of Foreign Affairs of Indonesia, I would like to express our sincere appreciation to the Indonesian Society of International Lecturers, and also to the Embassy of Republic of Indonesia in Vienna for the excellent collaboration in organizing this webinar. Your support and commitment have been instrumental in making today's event possible. We look forward to continuing this fruitful partnership through future seminars, workshops, and any other activities or collaboration to further promote the development of international space law in Indonesia. Thank you very much.
Thank you very much, Pak Widya, for the closing remarks. For now, Excellencies, distinguished speakers, participants, we have now come to the conclusion of the webinar on the contemporary legal issues in space laws, recent developments under the UN Corpus. Furthermore, I would like to convey our sincere gratitude to his Pak Ricky Suhendar, Pak Widya Rahmanto, Professor Ari Afriansyah, and our distinguished speakers, Ms. Rosana Hoffman, and also our moderator, Mr. Alif Nur Fahri, and all participants who have joined us today. We hope that today's exchange has contributed to a deeper understanding of contemporary developments in international space law and has encouraged further dialogue and cooperation among governments, international international organizations, academics, practitioners, and the relevant stakeholders. Thank you for the participation and kind attention. The webinar is now officially concluded. Have a pleasant afternoon and morning. Thank you.
Thank you
Thank
very
you very
much,
much.
everyone.
Thank you very
Terima
much.
kasih. Thank you so
Thank you, Pak
much.
Widi.
Terima
Bye-bye.
kasih
Thank
Pak
you.
Dubes, Prof.
Thank you.
Damos.
Have a great day. Bye-bye.
Bye-bye.